This is Aaron Nason with Richards and Drusik Immigration Law. Today I wanted to talk to you a little bit about petitions for writs of mandamus, or Mandamus petitions for short, and just kind of give you a little bit of an overview of the process when you file a mandamus petition, and maybe a little bit of a sneak peek behind the scenes as to what happens during this process. So first of all, what is a mandamus petition in the context of immigration delay? Well, simply put, it's a application to a U.S. district judge asking that judge to order USCIS or the State Department or the other government agencies involved to make a decision about your application that has been pending for an unreasonable period of time. And what constitutes unreasonable is decided by case law, it's decided by statute sometimes, and it can differ depending on the type of application. So the idea of suing the government for some people is really, really intimidating, and I completely get that, especially since they have your application, and there is a concern that they may deny your application in retaliation for suing them. Let me just start off by saying that this almost never happens, if ever it happens. Look, there are a lot of people applying for immigration status in the United States, and they're applying with USCIS, they're applying with the State Department, and the lines can be long, and sometimes the processes aren't as efficient as we'd want them to be, and sometimes there are just not enough people to decide the applications. As I noted in another video, we may actually see more delays due to a lack of people to process these applications. The majority of people working on these cases, the vast majority of them, are good people just trying to do the best job that they can. And sometimes applications slip through the cracks. Sometimes they're caught in background checks with other agencies. Sometimes they are misplaced. Sometimes they're just buried underneath piles of other applications. It happens. But a mandamus petition is just a way to tap them on the shoulder and say, hey, my application is pending. Can you decide it, please? So there's no retaliation. It's just simply a reminder to the government that it needs to take place, that your application needs to be decided. So how does this work? Well, I'm going to tell you from my vantage point. Now, first of all, you can file one on your own. You don't have to have an attorney, though I would strongly suggest that because you will be suing the U.S. government, having an attorney is a good idea, because there's lots of twists and turns and there's a lot of legal complexity that can go into this. So let me tell you about this from my vantage point. So when a client comes to me and says my application has been pending for a long period of time, I ask them for all of their documentation. I ask them for any receipts that they've received pertaining to their application. This could include receipts that the government has received the application, receipts about biometric appointments, and that biometrics have been taken, everything. I want to see it all. I want to see any correspondence you've had with the embassy, the consulate, or USCIS, or whichever agency is involved, with them telling you about how long the application has been pending or how long your case has been in administrative processing if it's a visa. I also want to see any correspondence you might have had with the U.S. government or with the members of the House of Representatives or the members of the U.S. Senate, if you've asked them to try to help out with your application. I want to just see everything. And then I make a determination based on case law, based on statute, and based on a wide variety of factors as to whether or not you have a case. And a large part of this is what constitutes an unreasonable period of time. That can differ based on application. It can differ based on court jurisdiction. There's just a whole lot of complexity that can go into this analysis. But if I determine that you have a case, then we file the petition, or we prepare the petition and then file it. But the petition is basically, it's a relatively short document, maybe 10 pages or so. We include some legal formalities such as who all the parties are, why does a court have jurisdiction, what statutes are we suing under, etc. And then we lay out all of the facts in your case. We talk about who you are. We talk about what kind of application you filed, when you filed it, how long you've been waiting. We talk about efforts that you've made to move the application along, and we put all of that in there. And then we go to the legal component of the petition, which is essentially an argument section in which we outline case law and we outline statutes and regulations that 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 require the government to act on your application. Then we outline our causes of action, which are basically this is what the government did wrong, and then what the government owes us based on our argument section. And then we finally ask the court for specific relief. We ask the court for a specific order, ordering the government to adjudicate your application. Once we get that together and you approve it, we then file it with the court, and then we serve it on the defendants in your case. Now, the defendants, or what we also call the respondents in some cases, can be both the agency like USCIS or the consulate or the embassy or the Department of State or whoever, and individuals within those agencies who are responsible for supervising the adjudication of your application. We also provide copies to the Attorney General of the United States, because we're required to by the rules, and to the U.S. Attorney's Office that works in the court where we are filing this petition. Now, what happens next can really vary depending on the application and depending on the attorneys handling it. Usually, these cases are handled by assistant U.S. attorneys. And these are attorneys who work for the Department of Justice, and they handle civil litigation. Sometimes attorneys from Washington, D.C., who work for a department of the DOJ called the Office of Immigration Litigation, will either handle it or they will be involved in handling it. And then the government has 60 days to respond. Now, what happens behind the scenes in those 60 days? Well, the attorneys handling it for the Department of Justice will usually reach out to their client and say, who could be USCIS or the State Department, and say, we've got this lawsuit, what do we do with it? Like, what's going on? And so they'll get information from their clients about the application and your application, and then proceed to give them instructions. Now, in many cases, not all cases, but in many cases, it's simply a question of the application has been misplaced or it's buried underneath a pile of other applications, and the U.S. Attorney's Office will be able to coordinate with their client and get the application adjudicated within 60 days. Very simple. In other cases, it may take a little bit longer, and so the government attorney will come back to me and say, hey, can we have another 60 days or 90 days or 120 days or whatever it might be, because we need just a little bit more time to get this adjudicated. And the government will say, and then I'll say, yeah, you can have that. We'll set it up for 30 or 60 days or whatever it is, and the application gets adjudicated and the case is done. In some cases, what will happen is the agency will come back to the Department of Justice and say, we don't really agree with their allegations. Like, maybe we sent a request for evidence that was never received, or maybe the case law is wrong, or maybe we don't have a duty to adjudicate this specific application. And so the government will then come back and they'll file papers called a motion to dismiss or a motion for summary judgment. And these are basically requests to the court saying, look, they don't really have a case, or the law isn't on their side. Can you just dismiss the case? And when that happens, then I come back and I file my own papers defending you and basically saying, no, this is why the law applies and whatever. And in some cases, if it's a certain kind of motion, I'll say, no, we need time to get more facts. We're going to need documents from the government. And it continues forward. And then when all of that is done, then the judge issues a decision in the case. Again, the vast majority of these cases settle pretty quickly. And this is especially true if, going back to the very first step of the process, the case is set up properly, if a proper evaluation is done on your case. There are times when I have to tell a client, well, I don't think you have a case right now. Maybe you haven't been waiting long enough, or maybe the court is all wrong for this kind of case, whatever it might be. And the reason that we do that is because we don't want to waste your time and money, especially if you don't have a case. But for the vast majority of all the cases that we file, these cases get resolved relatively quickly because we do our best to set them up properly. I hope this has given you a little bit of background about what happens with mandamus petitions, both behind the scenes. If you have any questions, please feel free to contact us at Richardson Jerusik Immigration Law. If your application has been stuck and you'd like a consult as to whether or not you have a case or not, please feel free to reach out to us as well. Thank you so much and have a great day.